Hello, everybody. Just to begin with, I want to thank the organizers and my Hungarian friends for this very kind invitation and for the excellent preparation of the conference and your hospitality. I just want to begin with a question why I am here. I think majority of you who are now listening to me have the same question, because if you look at the list of international speakers here, you see Americans. There is no question about them. They are everywhere. So Americans can be here and there. They are interested in everything, and they are always kindly invited and hosted everywhere. So there is no question about them. Srđan is from Croatia, is a close neighbor, and he can be very interestingly hosted and listened here. So I'm from Georgia, and why I am here and what can I tell you which might be interesting for you? I think the answer on this question is that the problems I will speak about are the same. And this is very challenging and amazing that the problems which the ADR society has worldwide are very similar and the same. So what I did just to make my presentation more interesting is that I interviewed several people from different countries, the mediation practitioners who do this work in different post-Soviet countries. I put several questions about ADR culture. Of course, I will not go deep in social philosophy to speak what forms the ADR culture and so on, but there are several criteria, I guess, and some of the colleagues will also agree, which forms the ADR culture. And these criteria are a law, which of course is very important to form the culture, and to implement the new tool which has never existed before, politics, because without support of politicians you cannot push things forward, business and NGOs, so the society, the civil society should be active to respond to the new tools, not only in dispute resolution, in every single thing you will try to develop in different countries, and the lawyers. So these four criteria, I think, works and impacts very significantly what we call ADR culture. And I put those questions to different practitioners from different countries, and of course I will talk myself about Georgia, but I will make several quotations also of the people who are working in different countries and who are very busy with mediation issues in those countries. So in terms of law, the mediation law has become very important during the last decade, because before there was an idea, and this idea was very intensively pushed and is still pushed by different practitioners, that law is not important to develop mediation, that there are some jurisdictions where mediation works and works very good without legal provisions. So I think this idea has become a bit questionable now, because at least to make mediation popular, you need to have a law which sends the message to people that this is legal. Because I, as a mediator, when we begin in 2011 to convince businesses in Georgia to use mediation as a tool, and there was no law for that time, the very first question I was receiving from business, is this legal? So can you do that? What will be the position of judges and politicians and the government? And there was no answer. The only answer we could say is that this is not forbidden by the law. Of course, this is not in the law, but this is not forbidden. And as you know, the business is very conservative, very skeptic, and of course, this answer was not enough. And for that time, I remember when we gave the chance to the students in Tbilisi State University, where I teach mediation, to select a mediation class, there was a mistake in the curriculum, and my assistant wrote there meditation. So, and nobody noticed this mistake, because mediation, both of them for law faculty was very, very unfamiliar. So nobody could just realize that I was not going to teach meditation to law students. So, of course, when there is no awareness, law can play a role to raise this awareness, to give more arguments to people, to business, to NGOs, to individuals to use this tool, to use this system. And these countries have different perspectives, including Georgia from the legal perspective, so to say. Of course, arbitration is older in those countries, in late 90s, early 2001, 2002. These years were the years when the arbitration laws were passed in different countries. Like Azerbaijan, for example, was the first, and not because that Azerbaijan is the most friendly or most arbitration-friendly country, because of gas and oil, and because of an urgent need of international investments in this industry. And of course, those companies who are involved in this business could not feel comfortable without having good international arbitration background, legal background in the country where they were going to invest in. So there were several other reasons in different countries, including Georgia, to push forward the arbitration laws. But with mediation, things were developing and still develop very differently. Because there is no business who is pushing, or international investor who is pushing the government to pass the law on mediation. And for example, in Ukraine, we don't have a law at all. And as our colleague Galina told me, there were 11 attempts in the parliament to pass the mediation law, and all of them failed. So I don't know what is the reason, what are the reasons. Maybe there are myriad number of reasons for this, but the fact itself that the country is not able to pass the mediation law means that there are several obstacles for such developments. I just want to quote Galina with her words. Personally, I do not want a law because of risks to be over-regulated. This is the biggest fear we as mediators have everywhere, and especially in post-Soviet countries, where everything was regulated. There was a period, 70 years of life, of people who were alive and who were still working and very active, and these people were seeing every day that every single detail of their life were regulated. So the mediators now see a big problem and have a fear that if there is a law of mediation, then there is no room for mediation, because the law can just kill this very effective tool, which is developed as a private initiative. As we know, the history of mediation is not that somebody in Congress or in Senate has thought that this is a good tool and brought a bill in Coliseum. This was not a case. The case was that the private practitioners who were great believers of ADR has developed it as a private tool, and then the government has followed. So the same is happening in Kyrgyzstan. So I would quote Fidana from Kyrgyzstan, our colleague, who says that, "I believe that mediation can be developed without any law, especially at the beginning. mediation should not be over-regulated, and there are attempts to do it here, in Kyrgyzstan. So you cannot blame anybody in this. So this is very cultural, because these people have this experience that if all the details are not in the law, then the law has shortcomings. This is the stereotype which works and still in force in those countries. So the question is, considering all the things I have mentioned, the question is, how can the law impact the mediation development? I think the first mission for the law to impact the mediation development in the country is the popularization of this tool. Because the law gives the answer to the question which was put to me very intensively 9 years ago: is this legal? Now we can answer in Georgia, in Azerbaijan, in Kyrgyzstan, but not in Ukraine, that yes, this is legal. And this answer, of course, can be very helpful. And Azerbaijan is a very interesting example for this. Because from the beginning of 2011, 2012, 13, and the following years, Georgia was the leader. And I'm not biased now. Georgia was the leader in the region, just developing these things, amending the civil procedural code with court-based mediation, implementation of court-based mediation. But now I need to accept that now Azerbaijan took this leadership, because what they did with the law, and I think this is the most important tool to impact that development, they adopted the CEPG, the Commission for Effective Justice, European Commission for Effective Justice System, has worked out, maybe some of them are aware of this model law on mediation. And this model law is developed by a very nice and good group of experts. And one of the experts is from Italy. His name is Leonardo D'Urso. And Leo and his colleagues and friends have developed a very nice tool which was mentioned yesterday, and there was a very nice comparison when you just allow or bring or let the horses to go to the river, and then they decide whether or not to drink the water from the river. So just to give the opportunity to everybody who has no idea what mediation is, to try mediation, and then to decide whether it is good or bad for them. So this tool, which is working very well in Italy after this constitutional law battle, which was won, I think, by mediation. Of course, it was a big impediment for a couple of years, but now everything is much more better than it was for that time. But this experience was shared by Azerbaijan, and their law also obliges to make this kind of first attempt. So when you go to court, you have to try mediation, but of course there is no obligation to settle, but there is an obligation to try. And I think this obligation will help to raise awareness about mediation. And of course, this will increase the number of cases. Maybe there will be a lot of questions, and we mediators know that when you open your mouth, you're making mistakes, sorry. You're making mistakes, and then you realize you made this mistake, then you're coming back to these mistakes and try to somehow resolve the problem which you inspired. So I think this example, the Azerbaijani example, is a good example for us also, for Georgians, and we have decided in favor of more US-American style, so to say, and to develop mediation with the court-based mediation programs, where the judges in the courtrooms, as it was happening at the very beginning in the several states in the US, are referring cases to mediation, despite the reluctance of the parties, despite their hostile attitude to mediation. They are still referring cases and convincing parties to try mediation. And about a week ago, I was approached as an expert by several international donors in Georgia who want to train judges, who need to refer the cases to mediation. So they want to improve the convincing skills of judges to refer the cases to mediation. So just to make some kind of summary how the law can impact, I think there are two alternatives now in post-Soviet countries. The first is Azerbaijani example, which means that the law makes it obligatory and you have to go to mediation, or the law, as it is already stipulated in Georgian mediation law, which was enacted by the Georgian parliament 3 weeks ago, so it's brand new, that mediation should be developed through court-based programs. I think the question which one is better is not polite. I think even both of them can be used simultaneously, and they are not alternatives to each other. So I think they can develop mediation culture, they can form mediation culture, which unfortunately is not developed in our country, in post-Soviet countries, but every country has these tools in their social life historically when there were people who have social authority, so to say, not a legal authority, but a social authority to resolve disputes, to be an intermediary in disputes as a third and neutral person. This was also happening in Azerbaijan, in Middle Asia, in Georgia, in Armenia. So I think the law, and maybe it's up to you to decide whether it's true in Hungary also. I don't know, I'm not an expert how mediation and ADR is developing in Hungary, but I think we have to think and decide together how to give to the law this new mission. Because law, we are lawyers, I guess, and we think, when we think about the law, we always say that law regulates. The main mission for the law is regulation. But now we are giving the additional missions to the law to raise awareness, to make mediation popular. And this is not a natural role for lawmakers. And I think this is a very challenging time now in the post-Soviet space where the lawmakers are putting these questions how law can develop or help mediators to develop their business. So the politics and governments. So how the governments can be helpful in this. I have a quote from our colleague and friend from Armenia, and I like this expression very much. He says, government has been passively supportive. Can you just imagine what does it mean to be passively? If you support anything, you are not passive, you are active, right? But the government in Armenia has been passively supportive. So, of course, you can criticize for this passive support, the governments, but I think this is the very right approach. Because if government is pushing hard, and I remember when there were several examples when the government members were pushing hard, then there was a big skeptic of business. Because business always thinks that they need to be careful, at least in post-Soviet countries. They need to be careful, and when there is a thing that is very intensively pushed by the government, there might be a danger. So for that reason, I think to be passively supportive from the government side is very important, at least in countries like Georgia or Armenia or Azerbaijan. But on the other hand, I have also heard these words from different officials in Georgia that we are not against, if you want to use it, it was 5 years ago, 6 years ago, if you want to use it, you can do that. You can feel free to use it. We are not against it. So I think this position, at least, is the minimum standard which should be somehow conducted by the governments in order to support mediation in those countries. But I have another quote from Mushek, which says that despite the law, we have not certified mediators since 2015. So Armenia has passed the law on mediation in 2015, but since 2015, there is no mediators in the countries. So nobody is interested. If you blame the government that they made the law, but they did not make the campaign and so on, I think it will be a big mistake. Because the society and the mediators should be more active, I think. And mediators in those countries have fear. They don't have resources, they are not supported by the private mediators. The public initiatives are more supported by international donors, as you know, in those countries. And the private people who are really big believers of mediation don't feel comfortable to be very convincing, to be aggressive, I would say, to push mediation hard. So I think the main problem for them is that they need to be, and we need to be more active. We need to be more active when there is a legal framework which gives us an opportunity to be, and to increase the number of mediators and to increase the stake where the mediation can be helpful. And when government is passively supportive and the private sector also follows this, of course no mediation can be developed. So I think these two quotes shows us the main obstacles which can be a big problem for mediation in those countries. And business and NGOs, as I've already mentioned, NGOs sometimes are politically motivated. They have different political missions, at least in the countries I'm talking about. For that, NGOs, some of them are not that much active. I mean, the internationally reputable NGOs, that much active in ADR developments. They prefer to be focused on more constitutional law issues or some power balance in the parliament or something like this. This is more interesting for them than to speak or talk about the development of ADR tools. So the society and the passive position of society is very nicely reflected in another quote from Galina, from Ukraine. People like delegating responsibility for their life and difficult situations to the state, to the court, to everybody. So nobody, this is the problem which had never been mentioned as a problem about mediation. When we talk about self-determination in mediation, we say it's the positive context, that the self-determination means that we, as a parties of the dispute, can decide ourselves and can say no or yes to the conditions we are offered to accept or reject. But this high level of self-determination in mediation inspires fear in people in the countries where everything was controlled. So people were not making decisions by themselves, and now when mediator asks them, are you okay with this? Would you like, or in the American style, would you be willing to? And their answer always is, as a lawyer who represents parties in mediators, the question always comes to me saying that, what would you do if this is your case? And I'm always trying to explain to the clients that, of course, I have my own opinion, but this is not my case. I'm an advisor. I can only advise, but the final decision should be made by you, because this is your case. And I remember the faces of people when I'm talking about it to them, they have fears in their eyes and they don't know how to react because they don't have this kind of experience. Because the culture does not allow them, when you are 60 years old businessman in Georgia or in Ukraine, and you are asked to give a final answer in a couple of minutes or seconds, this is not natural for you, because you have never done it this way. It was not done in this way in your country, and you are 60 years old and your life experience does not allow you to say, oh, I like it, I don't like it, because you have never expressed your opinions in this way. For that reason, I think the main problem for mediators in those countries will be to make people sure that making decisions is even a pleasant job. It's good for them to make their own decisions, even to make their own mistakes. Because when you are a doctor or an engineer and a famous and very well-developed, with very well-developed business in Armenia or Azerbaijan or Georgia, Ukraine, you want your son to be a doctor as well. Because he will have the business, he has to follow your style of life, and even he has to follow your mistakes you've made. He is not allowed to make his own mistakes. This was also a very cultural thing. And to say to my 12 years old son, I remember that you have to make your own mistakes, and I will not interfere. I remember the eyes of my father, because he has fear in his eyes. What are you talking about? He's 12 years old. He cannot decide what kind of mistakes he can make. I think this is the main point which should be changed culturally. Those countries that, of course, when you are 12 years old, you cannot make a mistake like 40 years old. You are making your 12 years old mistakes. And when you are free, of course, you can be advised, there can be several recommendations, but your mistakes are your mistakes. This is maybe a very simple idea, but it's not very simple in those countries. And we have to consider this when approaching them and when talking about mediations. And these 11 attempts of passing mediation law also is a good evidence, because somebody cannot decide whether it's good or bad for them. And this lack of decision-making power is a big impediment for mediation developments in those countries. And lawyers, the final criteria, how can we form the mediation culture? Maybe lawyers are the same everywhere, at least towards arbitration and mediation. From the very beginning, they are hostile. They think that this is not the tool which can really help their clients, or even if it is a good tool to help their clients, this can just leave them without their own bread. If everything is resolved by mediation, and this question was put yesterday to judge, who was a presenter from a judge, who was a listener here, that if all cases are resolved by mediation, what can we do as judges? What's your recommendation as a judge to do if all the cases are resolved by mediation? Of course, not all the cases have resources to be resolved through mediation, as it is taught in mediation classes in different places. When there is only one way to decide, it's a deadlock. When there are two ways, it's a dilemma, and only 3 ways can give you a good reason to mediate. If there are at least 3 alternatives how to resolve, then of course you have the good platform to mediate the dispute. Not all the disputes have this resource to be mediated. And when I asked my colleagues about the lawyers, of course everybody is complaining that lawyers are hostile, lawyers are against, they try to fight against mediation, or what's happening now in Georgia, for example, when they see that mediation is pushed forward by the government and the business is also positive. Now what they want to do is that just to, I want to use this word, acquire mediation. They want to own mediation by themselves, and they don't want to allow other professions to be in. And there is a big battle now, who will certify mediators in Georgia? Who will confirm the accredited programs for mediators? And the lawyers are more aggressive to say that only lawyers can do. This, maybe the psychologists or accountants can also mediate, why not? But they should be accredited and confirmed as mediators only by the lawyers. Of course, this is a problem, but as it was mentioned by Sir John yesterday, when there is a problem, there is a perspective. The problem means that these people are interested. This is the good news. But now we have to explain them, it was my idea, that they are very negatively interested. We have to explain to these people that the bigger the stake is, the bigger can be the slice of the steak to those people who are now trying to close the profession. The open you are, and the mediators are the most delicate and most open people in the world. So they are very communicative, not because of the professional skills, because every good mediator understands if you are open and if you open all the doors, and the more people trust mediation, the better for you as a mediator, because the more disputes can be referred to you. And as the parties' will is the most important thing in mediation, the open you are, the best for your client or yourself. I just want to finish my presentation with the quotation from Azerbaijan. Ruslan from Azerbaijan told me that the biggest challenge for mediation in Azerbaijan is the belief among the population if they cannot solve their problem, no third party can help them. So this is also a very, very natural explanations for lawyers and for people. I remember the face of a head of one of the biggest commercial banks in the region, who is dealing with the problematic assets of the bank, saying that we are dealing with these people, we're talking to these people 18 months, 1/8, and what can you do with them? They fail to pay, and within these 18 months, we do not have any progress. And now you say that you can do this better than we. What is the reason? How can you do this? And he said he needed very detailed explanations. How can I do that? Of course, for more than 35,000 cases that they have, I cannot give them the explanations. How can I do every single case? But I strongly believe, and I have a meeting with him next Monday, and I have got 15 minutes to convince him how can I do this with the 35,000 cases they have got in the region, and they are very concerned with. I think this is also about to change the culture. If I will be successful on Monday, it means that very slowly the culture is beginning to be changed. If not, maybe next time. So thank you very much for your attention, and ready to answer any questions if there are.